off by saying that, when you think of a bank, like any other organization, any other commercial entity, you've got assets and you've got liabilities, right? And for a bank, what confuses a lot of people is that the deposits that you go and put in the bank is not an asset of the bank. It's a liability of the bank. It's almost like a debt. It's a loan you give to the bank. And obviously, the bank then gives out loans, and those loans are the bank's main assets. Of course, the bank can also borrow money to on lend, and if they borrow the money, that money will also be liabilities or debts. Let's just use that term, debt. And then their shareholders themselves to put in some money, because without significant equity as a shareholder, you're not allowed to start a bank in the first place. So that's the starting point. Now, the point about the shareholders putting in money is very important, and I'll explain in a minute why that's so critical. For banks, you need shareholders to put in a minimum amount of money, which is not the case in many other businesses. And the reason is because banks have a very particular risk attached to them due to the fact that the money that we put there as deposits, when they lend it out, they do so pretending, so this is like a magical kind of thing, pretending as if that amount of money, even though it's a call deposit, I can come in and pick it up anytime I want. They make it look, they pretend as if that money is being given to them for long term, but it's not really long term. I can show up tomorrow to pick up the money. Yet they often lend it out long term, 5 years, 2 years, 1 year, whatever. So because of this delicacy around the way banks are structured, you need what we call prudential regulations to be extremely strict, otherwise you get trouble. So this is where we get into the UniBank matter. Essentially, the way banks have been structured as public utilities, because of the delicacy of the whole operation and the risks that are attached, banks cannot be run like any other business, is the point I'm trying to make. So we get into UniBank, which is a bank that, until 2017, actually until 2018, was regarded as one of the best banks in Ghana, one of the best growing. It was, very often on the Club 100, which is the list of most prestigious banks in the country. It had 370,000 individual customer accounts and over 400,000 accounts if you count the corporate and other accounts. $1.25 billion in assets. It's a big bank, essentially. And if you go to December 2016 and you look at the balance sheet of UniBank, absolutely nothing was out of gear. Everything seemed to be in place. It was a bank that was doing very well and seemed very profitable, as you can see on the balance sheet, in terms of the total equity way above the minimum equity that was then required, etc. What we didn't know until much later was that certain aspects of this balance sheet that you see was not actually what it is. Essentially, these audited financial statements that were published, it was also a listed company on the stock market, and therefore it had rules that it had to comply with. Some of that stuff was not correct. So I'll give an example. Even though it was seriously on liquidity support, chronic liquidity support from the Bank of Ghana, that was not somehow reflected on its statement. So you wouldn't really see the full extent of its liabilities if you look at the statement. And certainly that situation worsened in 2017, where it moved from about 850 million Ghana cedis to over 1 billion Ghana cedis in terms of monthly support that it was getting from the Bank of, in terms of annual support that it was getting from the Bank of Ghana. On top of that, when you look at these regulatory disclosures, what it was telling the regulators, it suggested that its non-performing loans was just about 5.34%. This was December 2016. The truth, in fact, was that things were far worse at the bank than anybody knew, because its disclosures, what it was publishing in audited accounts and the rest of it, were not correct. So, for instance, as of 31st December 2017, the banking supervision department at the Bank of Ghana, based on the audits that they did subsequently when these matters came to their attention, showed that they had overstated the loans that they were publicizing by about 1.3 billion Ghana cedis, and that some of the loans that they had actually given out under the so-called other assets category, most of which had gone to their own companies that they owned, had also been understated by about 3.8 billion. And that customer deposits, this is actually quite frightening. Customer deposits balance had been understated by up to 2.3 billion. So in those days, that amount of money was in excess of $500 million. So there were about $500 million of customer deposits that they just simply were not disclosing. to the Bank of Ghana. Later on, UniBank will suggest that part of it was due to a problem with their banking system. They had the terminus software, and they did a cutoff, and it caused chaos in their numbers, etc., etc. Whatever be the excuse, the truth of the matter was that we did not really know what was going on in this bank, even though it was an audit. It was a bank that was listed on the stock exchange. It was audited and was regularly supervised by the Bank of Ghana. It was later when it came under heightened scrutiny. The Bank of Ghana was sending people there almost every month to audit, that they begin to understand the real problem that was going on. Secondly, there was also significant activities, in this bank where, for instance, they had borrowed money significant from international banks like Afrexim Bank to achieve particular purposes and were using for something else, etc. But the key principle is this bank was such a big bank that it was systematically important. What that means is when you are looking at it as a regulator, you're not only looking at the bank in terms of its own situation. You're looking at the impact it can have on the entire financial system. And part of the reason was because it had exposures and etc. to other banks, some of which I've listed like ADB, GCB, etc. And therefore, Prudential Bank, for instance, was heavily exposed to it. And if you didn't manage UniBank properly, you're going to damage the entire financial system. So the question really here is that we had a bank, it had huge problems. Because banks are not like normal business, you can't just shut them down and walk away. The government has to step in and clean up after the bank. So my point is, how much has the country lost as a consequence of cleaning up after the bank in ways in which we could not have avoided? And then on top of that, how much of that money could potentially still be with the former shareholders? And therefore, what is the fair amount to recoup? This is a different question from the question that I think a lot of people are asking, which is what is the amount that the government was trying to get in court, etc. And I will explain why there's a fundamental difference between the two discussions in a minute. But the simple reality is that you simply have to go to the latest analysis of the balance sheet of UniBank, basically what it owned and what it owes, right? As of March 2025, that is the latest that is publicly available. So March 2025 is later than some of the court documents that are
whole lot
flying around, which date
about shareholders having stolen money.
When you look at the numbers that have been,
miserable
analyzed and assessed by the regulator, by the receiver,
circles,
by that
have shareholders stealing money.
You come to the conclusion that
because of this plan,
a certain amount of money that as a country we put behind
the bank had taken the position which had been brought up at board meetings,
and that really is what we are looking at.
The minutes are there.
So when you look at on this balance sheet that I'm just displaying,
assets should be held.
It's very simple.
Special purpose vehicles.
How much of
when the receiver, the official administrator came upon the bank, these things were disclosed to the administrator at that stage. They were not hidden. And that's why in the letter of 5th June 2018, you see in the third paragraph, they talk of immediately assigned holders' interest in the assets sitting in the books of the bank. More or less, parts of other assets of about 3.7 billion, which were purchased by the bank, but registered in the name of holder to improve the solvency of the bank.
And some good assets. How much do we get when we try to clean up? And when you look at that figure, it's on this chart right here, which is from the receivers. It was literally about 711 million. But the critical point is that when you look at UniBank's balance sheet, and it tells you what it borrowed in terms of deposits, the money that people went to put there. It borrowed from other banks, it borrowed from the Bank of Ghana, and what it bought with what it borrowed. Because when you, in a business, it's very simple. You take money from other people and you invest it into assets that create money. So what you borrow, it's in this case of a bank, is the deposits people put there, it's what the Bank of Ghana gave them as support, it's what they borrow from other banks, and then they must use that money to buy assets, which then generates money. What are some of these assets? Loans you make. It's a very good example. Treasury bills you buy, etc. So when you look at the proper assets that were transferred to CBG, and this is all data that has been analyzed as of March 2015, there's only about 711 million that went to CBG. The rest of it have to be adjusted. And when you adjust and you look at the impairments, the money that we can't find, the money that we can't trace, etc., etc., you come to the conclusion that as much as about 7 billion Ghana cedis. Remember though that this is 7 billion Ghana cedis frozen at 2018. That point will be important. I'll come back to that. Nearly 7 billion cedis could not be traced or was not available to hand over to CBG. And somehow, in different ways, this country has absorbed that loss. How did we absorb that loss? All the deposits that you had in UniBank, over $4 billion, which is about $1 billion at that time, that deposits, the government had to make sure those deposits were good. The money that the Bank of Ghana had lent to them, which was in excess of 3-something billion, and if you take the unsecured portion alone, essentially you offset it with what UniBank had with Bank of Ghana, it was almost 3 billion. That money can still not be recouped and given to ECBG. So you add all of that together, that is what I am talking about. So I'm talking about the money that the country has lost. When it comes to what the government tried to retrieve in court, they were focused on things they can prove emphatically within that adversarial process, which is the courtroom. And that's not the only place in which accountability is handled. And that is the difference between my analysis and some of the analysis that I've seen flying around. So essentially, you go into the UniBank books and you try to understand where did the money go. And that is where you begin to notice that a lot of the money eventually went to related parties, essentially went to companies that are very closely related to UniBank. And then some of it also due to the way in which those approvals were made, there was a belief that a high degree of liability attached to UniBank's senior executives and shareholders. And therefore, if we went to court and we said for these amounts of money, the court should help us to pull back, we stand a better chance of prevailing in the court. That's not the same as trying to trace the money we cannot at this stage put our hands on and pass on to CBG. That's a different conversation. So you say, okay, there is a lot of money missing. Some of that money, we know it went to companies that these same shareholders own. And I will show you a couple of them very soon. And so we can trace that money easily. And then some of them too, we can see that they've signed some documents and things like that. And we can pile all of that and we take it to court and say, look, for these amounts of money, we think these people should pay that money back. And this is a purely litigation strategy, a prosecution strategy. It is not entirely encapsulating all the money that this country has lost because we have to step in and clean up after UniBank. And that's a critical point that I'm trying to make. So the 7 billion that you saw on that page is not necessarily the 7 billion that is being pursued in court. It's money that through UniBank's various infractions and negligence, and maybe misfortunes as well, could not be traced and handed over to CBG. And for which reason this country had to step in and make good. And that really is the logic. So once that logic becomes clear, then the matter of separating that from the issue that everybody else seems to be focusing on, which is how much money did we trace to different companies that were owned by the same shareholders who owned UniBank, and how much of that reconciliation has been done, how much of that has been separated into monies that we've now traced to other companies, and we think we can target them directly. And I'll come to that point very soon. There are over 90 lawsuits that the receiver has filed chasing different companies directly. So in some of those instances, there's no point then in a courtroom to insist that, you are asking the judge to rule that this particular company is guilty of those particular infractions. And that differences, I think, is what's confusing people. But when you look on this sheet, for instance, you will see that there are a number of big companies that are owned by the same shareholders who were the majority shareholders in UniBank. So Numa Logistics, for instance, the associated funds, the other assets category, the money that somehow went to them is almost 1.7 billion. So essentially, we are talking of something like $400 million of UniBank's money going to this other company through various schemes and devices. Holder Holdings, which has many, many properties all over Accra and different parts of the country. A lot of integrated properties, Uni-Precision Printing, LHS, Urban Logistics. There were almost 30 companies that the owners of UniBank also owned that have received different kinds of support from UniBank. Some of them are letters of credit, some of them are whatever, some of them are loans, some of them are advances, etc., etc. Now, the analysis moves from how much money has this country lost in attempting to clean up behind UniBank to why I think that there's more money with the owners of UniBank or the former owners of UniBank, and therefore we should aim for more. Part of it is you have to look at the analysis of how some of that money moved to some of these companies. So there are companies like I've mentioned, Holder Holdings, Yawado, Numa Logistics, etc. And in many of these instances, the money was created out of thin air. So when the Attorney General says that the money that was lent to them were fictitious, was basically fictitious entries, and we shouldn't repeat them. He's misunderstanding the issue. The fictitious entries were the credits. So essentially, you pretend that there's money there that you are lending to someone, but actually you are using deposits to lend to that person. So it's not backed by full credits. So your liabilities are expanding without a corresponding increase in your assets. That's really what was happening. But it doesn't mean that the money didn't go to these companies. The money did go to these companies. We have all the records from the work that the receivers and before that the official administrator had done that establishes that. There were also monies that, for instance, they had used to buy bank insurance companies in Sierra Leone. They attempted to buy ADB, for instance, and they had moved the money into some other account because they wanted to buy a contract development bank. It's a whole range of activities where the monies had moved. Now, in some instances, we can't literally trace them. And I'll come to that point because it's very critical. It's not very clear who these entities are that have borrowed the money. It's been very difficult reaching them. We don't know how many of them are actually going concerns, and that made it very challenging. Some of the money too came from international. So Afrexim Bank, like I've told you, lent money that was supposed to go to LHS and BOST to do oil business, and that money somehow ended up not going to them. So all of that to say that when eventually all these facts came out, and the shareholders themselves were then confronted with the blatant evidence on record, they came up and admitted some liability, and they made proposals to put some money in the bank. Right. I've heard people talk about 2 billion Ghana cedis. That was not the only amount that they offered at that time. Remember that 2 billion Ghana cedis in 2018 was far higher than 2 billion cedis today. And I'll come back to that point again. When they made the offer of 2 billion cedis in 2018, they also offered to put 4.1 billion cedis of assets belonging to Holder, which is their holding company, which owns a lot of companies in Ghana, into the bank in order to patch up the bank. So when you look at what they themselves were willing to offer at that time, it was in excess of 6 billion. And that tells you the hole that was there and what the shareholders felt they could do in order obviously to avoid prosecution and in order to keep some of their other assets because the receivers were going after everything, right? So that tells you the scope of the liabilities that they were willing to admit at that time. And that was very important. And then when you look at why that proposal was not accepted, it tells you the scope of the problem. Because even that was considered not enough to close all the gaps, which is what you see on the left side of the screen, which were the gaps that will remain. There will still be a capital deficit, even if all those monies came back from the shareholders and went back into the bank. So that's very critical. Right. And the reason why it's important to use dollars in order to get the right sense of the recovery is because 2018, a CD was worth more than a CD today. If I give you a CD in 2018 and you simply just put it in treasury bills, by now you have way more. So if somebody owes us money from 2018 and is paying now without interest, it's an interest-free loan. So if you are doing the analysis properly, the simplest way, there are a lot of methods you can use, DCF methods, like a whole bunch of methods, but the simplest way to discount it and to kind of make the analysis a bit more wieldy is to take the dollar value then and the dollar value of what you are paying now. So when you strike the balance of that 7 billion that is missing in those days and how much in dollars it's worth, and the 2 billion that is being offered today, you get the point that I'm making around the 10% entry because the dollar values then change and the ratio becomes clear. Remember also that they are not paying all the 2 billion at once. They are paying 800 million cedis in property, which nobody has valued. And then over 18 months,
nobody has valued.
The government is hoping to recover some of the monies that have gone to other parties other than the related parties, which is exactly the same challenge the receiver has been on all along. So the critical issues, let's summarize again. By the time that the government went into to close,
so you are summarizing to conclude for me.
Yes, give me a few minutes. By that time, the liabilities, the total liabilities of UniBank, as you can see on the screen, was 9.4 billion. That's in excess of $2 billion. That was really what the issue was. And then the question was, how much of the money could you find in treasury bills, etc., in money that was in cash, etc. And then that money was about 2 billion. So if you take that out, you are left with the 7 billion cedis that I'm talking about. And then you look at where the money went, because essentially if you have all these liabilities, there must be corresponding assets. You find that a lot of it went to companies such as Numa, Holder, Integrated, UniPrecision. Some of those companies today, like UniPrecision, the name has been changed the asset in a way has become encumbered because the same shareholders have taken some loan from some company in some tax haven, and therefore they claim that they don't own it anymore. And even though they have rented the property out to some people, they have moved them. So a lot of the assets have become complicated. But the truth of the matter is that there's money that is in all of these companies. And in my view, given the money that went into them, it is very difficult to argue that the money that we are getting from them, which at this stage, in terms of the actual hardcore cash of about $60 million, is enough when the country has lost over almost $1.5 billion trying to clean up after UniBank. In terms of the debt owed, people have said that, okay, UniBank also, the government owed UniBank. Why don't you offset that? All that was calculated. UniBank itself, when it brought its numbers, was less than $1 billion in those days. That's cedis. And then, subsequently, there was validation at the Ministry of Finance, and that ended up with only about half of that. So that $500 million that the government owed them, when you offset, is when you still get these numbers that I'm talking about. Now, here is our problem with the AG's intervention, the Attorney General's intervention. The receiver that was appointed, it was appointed according to law. The law gives the receiver certain powers in Act 930, which is the Bank's Specialized Deposit Institutions Act. It's the receiver's job to go and get the money back and to maximize the recoveries. It's not anybody's job. The AG was just helping by filing the criminal lawsuit, which should have played the role of piling pressure on the shareholders or the former shareholders of UniBank. It was not the job of the AG to collect the money. It's the job of the receiver to collect the money according to law. On top of that, the same law also gives the receiver the power to disallow transactions that happen before receivership. So, for instance, all these related party things and the rest, that's why the receiver has a separate civil lawsuit ongoing. So for the AG to now enter in an attempt in a way to preempt what the receiver might do, to us is overreaching. It's acting clearly in excess of jurisdiction.
Okay.
The other point is also that the receiver has fiduciary responsibility to the Bank of Ghana. It's the Bank of Ghana that appoints the receiver. So if the Bank of Ghana itself has determined, this is a matter that has been well established in the Supreme Court case in 2023, where the current acting CJ himself reinforced the fact that the receiver acts as a fiduciary of the Bank of Ghana. So really, only the Bank of Ghana can terminate the receivership when the receiver has determined that he cannot recover any more money. And we should also remember that as I've already mentioned, there are several lawsuits that are ongoing, targeting direct individuals. And if we continue to make this kind of arrangement, then what are we telling all the other people that are also owing the company receivership?
Okay.
Essentially, if you're going to make a pact to one set of creditors, what about the rest?